If there is evidence of direct discrimination, you don't need to have proof of a pretext. So if there's very specific examples of discrimination, there's no need to prove pretext. But if the defense is the BFOQ, then you need to prove pretext. So you show pretext when you offer reasons for adverse employment actions that have no basis in fact. That pretext is an offered reason that does not actually motivate the adverse employment action, and also the offered reasons are insufficient to motivate the adverse action. In terms of hostile working environment based on age, some circuit courts actually recognize it, others do not. There is no Supreme Court precedent yet, but we will keep an eye on this and see if that changes coming up. But a prima facie case for hostile work environment under the Act means that the worker is 40 years or older, that the employee was harassed through words or actions based on age, that harassment unreasonably interfered with their work performance, etc. And the basis for inferring liability, it was a basis for inferring liability to the employer. So again, hostile working environment, it depends on the circuit courts. You should be aware of which circuit court you fall under. Some of them recognize it as an issue and others do not. There are things called waivers, which are allowed to some extent under the Older Workers Benefit Protection Act of 1990. It's an intentional relinquishment of a known right. So the OWBPA is around the legality and enforceability of retirement incentive programs to ensure that people are retiring without any adverse impact to them, and that they are not being coerced into retiring for any particular reason. So it prohibits age discrimination, the provision of benefits. It requires that every waiver be knowing and voluntary, and there are 7 required elements that you'll see on your checklist on page 655 in your textbook. An employer cannot obligate somebody to sign a waiver, particularly if it is defective. The employee is not required to give back any benefits that they received under that waiver. So if it is a defective waiver, they still get to keep the benefits that they had. A waiver may not bar the employee from filing a claim with the EEOC either. So if you sign a waiver and you think it's defective, you can file that claim, and you're not obligated to give back any benefits if it is found to be a defective waiver. OWBPA also contains provisions in connection with early retirement plans. So the same thing, you can't force someone into an early retirement plan. It has to be purely voluntary, etc. And you want to make sure that you're not pushing people to do something when they are completely capable of doing a job just because of their age. Statistical evidence can be used when you are addressing disparate impact cases. There is some skepticism relating to statistical evidence in age discrimination cases because there's just normal attrition in workforces. People leave for a whole host of reasons, so it is hard, but you can use some statistical evidence if you feel like it might be relevant to making your case around disparate impact. Differences of more than 2 or 3 standard deviations can be considered suspect. So we want to be doing our statistical analysis, but seeing whether or not there are some differences within 3 standard deviations in terms of the differences in the way we treat under 40 and over 40. Context is crucial, so statistics in and of themselves are not enough. It usually has to be assessed within the context of facts and circumstances, and then how those statistics are one piece of evidence in the entire context. There are a number of remedies that are available to people who make claims of age discrimination. One is what we call equitable relief. That relief is not in the form of money, but it could be a reinstatement, a promotion, or an injunction of some sort. It's not granted if adequate money damages have been given. So you can get equitable relief, but oftentimes if you're getting your job back or you've gotten money damages for back pay or front pay, then you may not be eligible for equitable relief. But it is within the realm of possibilities in terms of remedies. Monetary damages for pain and suffering is also not available under the ADEA. So pain and suffering is not a relevant issue here for ADEA. It's, again, different from Title VII. There can be liquidated damages, which is a predetermined amount of damages equal to the unpaid wage liability. This is for willful discrimination, which is obviously disparate treatment, not disparate impact. So we're aware, and just be aware, lack of training does not defeat a willfulness claim. So if someone says you willfully paid me less or you willfully treated me differently, just saying, well, I had no idea, I wasn't trained, that's not enough. Under ERISA, the Employee Retirement Income Security Act, it regulates benefits plans, including retirement plan provisions and things like that. So it does protect employees from wrongful denial of all sorts of benefits, particularly based on age. It is not covered. Age is not covered here. So there's no denial based on employee age as long as he or she is at least 21 as a full-time employee. But there are other factors out there, right? That have made some changes in the way ERISA is interpreted. Your textbook gets into some of those, but again, the goal here of ERISA is that we want to make sure that we are protecting our employees, that our retirement plans are being managed properly, that they're invested accordingly. But the Older Worker Benefits Act is sort of gets at, if there's some differential benefits between what I get paid as an older worker and what you get as a younger worker, then that's all covered under those guidelines. So we have a few management considerations. Number one, employers should evaluate the requirements of a position to make very clear what the knowledge, skills, and abilities are so that we're clear what skill level is needed, what knowledge level is needed, what ability level is needed, and then we assess everybody against those standards so that we're not just making a claim that only younger people can do something when older workers are more than capable of having the skill set to do many jobs. We want to locate those workers who are the most qualified for the position while not excluding older workers based on preconceived ideas. So those micro-targeting of your recruitment ads you have to be really careful, right? There's nothing wrong with micro-targeting as long as you're also making sure that older workers have access to similar ads or similar knowledge about position openings. We want to pay attention to the basis for decision-making and selection in connection with training and development opportunities also. So it's not just about bringing people into the organization, but it's also how we treat them once they're in here to make sure that they have opportunities for advancement and training opportunities so they could get promotions as well. There are additional management considerations, particularly around reductions in force or RIFs. Employers may not have retained adequate written analysis of performance. So what this comes back to is in doing performance evaluation and when we're analyzing the work output of our employees, make sure we've got good written documentation of good or bad workers, because if we don't have that documentation, that can be a problem for us when we're ready to do our reduction in force and someone claims that there is age discrimination or any other kinds of discrimination charges. Managers and supervisors will likely evaluate an employee as compared to other employees, record that all are good or better, that may undercut a performance-based RIF. So we have to train our people to not compare them to other employees, but to compare them to an objective standard that is set in your job analysis and job descriptions, right? What is the level of performance that we expect from people? It should be outlined generally in your job descriptions and codified in your performance evaluations. We want to make sure that people are able to do the work against a standard, not comparing people to each other. A RIF defense should describe the process that you used and the decision rules that you used for making your layoff decisions. And so again, we want to make sure that we have a system that's based on comparing people to a standard, and that our process, if it's based on performance, has to be based on performance standards, not based on how people compare against each other. Defense has holes if the process makes choices based on other factors Even if they're humanitarian factors, we have to make sure that we are consistently applying our decision rules and that they're not based on more subjective criteria. You want to be sure all employees periodically receive a good performance appraisal. I know a lot of organizations are stopping them, but this can be a problem for them if they're in a position where they have to do layoffs and things like that. This can come back to bite them. So our management tips. Number one, any job requirement on the basis of age is subject to the highest scrutiny. So be clear that you have done a good validation that at a particular age, someone absolutely does not have the skill set after a particular age. Review all termination decisions carefully in order to ensure fair procedures balanced across your workforce. So if we're terminating people, make sure that we're not terminating people just because they're older, that if we have very clear standards of performance and a process that we apply consistently, that should help us. Reductions in force are prone to problems if it's on salary economics. We want to have a very clear objective system and work that system. So do not include subjective criteria. We want to be careful about terminating older workers and replacing them with another worker who is over 40, but because that does not protect you from discrimination. So if you're terminating an older person and then the younger person, even if it's slightly younger, although still over 40, replaces them, that's still considered a form of discrimination. That it's about the older worker who's over 40 and anybody who's younger than them, even if they're also over 40. We want to make sure that we're training managers to consider possible accommodations for age. So how do we accommodate for age? What kind of reasonable accommodations can we make around age and age and abilities and things like that? We want to make sure we're reviewing all recruiting literature to remove all age-based classifications. So check your recruiting literature. Make sure we're not talking about young, vibrant workforces because that could be considered evidence of age discrimination in your workplace. You may not terminate an older worker based on their age, period. You should review the waiver of discrimination to ensure compliance with the OWBPA. So make sure your waivers are legitimate and are in compliance. We want to make sure that employers should never encourage nor permit age-based remarks or jokes, and to avoid the liability under the ADEA for age-related harassment. Lastly, employers should be sensitive about the inclinations in the past to single out workers over 40 for medical exams. If you're going to require a medical exam, everybody needs to get a medical exam, not just people over a certain age. We want to be careful of a situation where an older worker who is laid off for economic reasons offers to take a pay cut. Under the law, we cannot cut somebody's pay. Now, voluntarily, sure, but we also want to make sure if that offered pay cut is less than what they're being paying a younger replacement, that could be considered a form of age discrimination. And so if we cut the pay, we certainly would want to cut it to where it might be, a younger replacement. But really, I would avoid this circumstance entirely. I would not allow for that. Maybe a demotion, what have you, but fundamentally, we don't want to be cutting pay as a way of avoiding age discrimination charges. Remember that retaliation for filing a claim of age discrimination, like other elements of Title VII protections, is forbidden. Chances of retaliation occurring can be reduced by proper training and making sure that all employee handbooks address the issue of not retaliating, and make sure all your handbooks address issues of age discrimination. Make sure the terminology and the language in recruiting as well as employee handbooks are all devoid of age and vibrancy references.